Uber Wave, Wave standing for Wheelchair Accessible Vehicle, offers wheelchair accessible transportation. It operates in only 11 cities and in some foreign countries. Uber claims it has accessible service in so few cities because it is testing the best way to expand Uber Wave. However, its efforts to avoid increasing its accessible fleet becomes clear when one looks at the lawsuits against the company. Uber Wave debuted in May 2016 in London. It featured minivans with ramps and 4-point tie-down systems to secure wheelchairs that were driven by people trained to work with individuals with disabilities. In May 2017, Uber put over 70 new Waves on the road in Pennsylvania. However, people reported problems with these vehicles, such as broken ramps or ramps too steep for power wheelchairs to drive up. In November 2018, Uber joined Boston's paratransit pilot program aimed at making transportation more convenient and reliable through the Uber app. Unfortunately, people must register and qualify for the service, be traveling in certain areas, and deal with many other restrictions. Uber touts itself as being accessible and anti-discriminatory. And yet, despite the company's seeming commitment to accessibility, it actively tries to skirt the Americans with Disabilities Act when confronted with lawsuits. The ADA requires all companies whose primary business is transporting people to provide equal access to people with disabilities, including people with electric wheelchairs. Uber does not comply with the ADA in most of the cities it serves. The lawsuits against Uber were generated by people with disabilities throughout the country and revolve around Title III of the ADA. It prohibits private transportation companies and places of public accommodation from discriminating against people with disabilities and lists different types of discrimination. The 4 cases against Uber tell similar stories. They are Access Living of Metropolitan Chicago versus Uber Technologies, Crawford versus Uber Technologies, Namisnik versus Uber Technologies, and Ramos versus Uber Technologies. The plaintiffs use electric wheelchairs for mobility and would use Uber Wave if it was available in their cities. They claim that Uber does not provide people with disabilities equal access to its service and fails to make reasonable accommodations for them. Uber's defenses in each case are relatively the same. First, Uber claims it is not a covered entity under the ADA because its primary business is not transporting people. The plaintiffs in Access Living of Metropolitan Chicago versus Uber Technologies provided proof that Uber matches drivers with customers, controls the price of rides, and has specific guidelines drivers must follow to continue to drive for the company. The court found this sufficient to conclude that Uber's primary business is transporting people. Second, Uber claims it has very little control over its drivers, so it does not have the ability to ensure its drivers comply with the ADA. The evidence shows otherwise. The application process to become an Uber driver includes uploading the information on drivers' licenses, passing a background check, passing a test showing their knowledge of the city, and interviewing with an Uber employee. In addition, Uber exercises much control over its drivers, including setting fares, prohibiting drivers from arranging future rides with clients, and not allowing clients to request specific drivers. Third, Uber claims the ADA does not apply to the company because its drivers are independent contractors, and the ADA does not apply to independent contractors. In O'Connor versus Uber Technologies, the plaintiffs showed they provide a service to Uber, so they were presumed to be Uber's employees. Uber would not exist if the drivers did not perform a service to the company, because the drivers are the base of Uber's business. Uber's income depends on the rides that the drivers provide. Fourth, Uber claimed that the plaintiffs did not make a request for the company to modify its policies, so it did not have to make accommodations. Some courts have held that an ADA claim does not fail when the plaintiff does not make a specific request as long as the defendant is put on notice that it is not in compliance. Other courts ruled that the plaintiffs had to request accommodations and receive a denial. Still another theory is that if plaintiffs have actual knowledge of non-compliance and demonstrate that they are being deterred by such knowledge, they can seek an injunction without requesting accommodations. Fifth, Uber claims that the company is not a place of public accommodation because it does not operate out of a physical place, so the ADA does not apply to it. The Third, Fifth, Sixth, and Ninth Circuits say that public accommodations must be physical places. The First and Seventh Circuits disagreed because even public accommodations that have physical spaces do business remotely, and the spirit of the law is to make every service open to the public accessible to people with disabilities. While not committing itself to exactly the same position, the Second Circuit sided the First Circuit on this issue. However, the courts interpreted Uber's last two defenses. The courts found a way to rule for the plaintiffs. Uber has made some progress in providing UberWay for people who use electronic wheelchairs in a limited number of cities, but the progress does not sound promising since it has been so limited and Uber refuses to comment on the problems it is having with UberWave. However, the results of the lawsuits against Uber offer some hope that Uber will increase its accessibility in the future. Although they do not agree on some issues, the courts agree that Uber must be ADA compliant. For these reasons, it seems that if Uber improves its accessibility and expands UberWave in more cities, that progress will be the result of current and future lawsuits rather than of its own initiative.